here, all of you, and do we know if there's anybody in the ether at this point?
It hasn't loaded yet.
Oh, okay. So they're not actually listening to this yet, or?
As soon as it loads up, then I'll be able to see.
Okay.
Yeah, I'll let you know.
Oh, but it's begun.
It's on. Okay, so anyway, I'm happy to be here to talk about this particular topic, which is one of those interfaces between the world of medicine, although not exclusively medicine, because the world of psychology also interfaces with the world of the law. And that's always an interesting relationship between the law and medicine. Not always an easy relationship. Come on in. Not always a comfortable relationship, but it's an important one, and I think it's important that there's a dialogue, that there's a conversation between those people in the medical and psychological professions who have some expertise that would be valuable to the courts in making their decisions. So today the topic is where there is a will. And I guess from the beginning, I just wanted to be clear what testamentary capacity was, because a lot of people are really not sure what testamentary capacity actually is. And testamentary capacity is one of the capacities that we possess, and that as humans, and that's an important capacity. It's a capacity to be able to execute a will. That is to determine. It wasn't always thus, not until mid-19th century in the UK. It wasn't always thus that people could determine where their property and estate would go after they died. There were statutory regulations, and there are still some countries in the world where you cannot determine entirely where your estate goes. There are certain statutes and regulations that affect that. But the word is a will. We call it a will because of the fact that it's what your will is, what your wishes are. We now live in a society that wants to respect your wishes. So what's a will? What do you want to happen after you die? And there are a lot of misconceptions that, you have to leave at least $1 to your children, or else the will is not valid. And there are a lot of myths out there, I think, still about wills. And of course, that's not the case. There are some regulations related to dependents and to wives after people die. But I'm just going to talk in general about the issue of testamentary capacity and also the related concept of undue influence, and you'll see that they tend to go hand in hand. Why is this important now? Well, we anticipate that in the coming generation there's going to be an increase to will challenges, actually not to testamentary capacity, to challenges to wills on the basis of testamentary capacity. So there is a legal option that people have available to them, and if they believe that someone has made a will and they were incapable or they were unduly influenced, then people have recourse to the courts and can challenge that will. And the challenge is often on the basis of both, frequently, lack of capacity or undue influence. And the reason that we think there's going to be an increase in these legal challenges is the demographics that we face, and that is, of course, a rapidly growing elderly population. Why is that important? Well, I've written economics. There is, in fact, contrary to maybe what a lot of people think, a disproportionate amount of societal wealth in the hands of older people. People who've owned houses for 50 years and the real estate has gone up. They've owned a farm in Alberta for 70 years, and that farm that was worth $2,000 in 1940 is now worth $2 million or more. So there is a lot of, and we are about to see, from a societal point of view, we are about to see the biggest transfer of wealth from one generation to another in the history of civilization. So that's a fact. So why is that relevant? Well, we have growing elderly population who have a lot of money to transfer, and this elderly population, we know, in terms of prevalence of mental disorders, has a high prevalence of mental illness, mental disorders. And of course, in the elderly, the big one is dementia. And dementia is a condition that could affect capacity or could make people vulnerable to undue influence. So you now have an added component. Growing elderly population, a lot of money to transfer, and a high prevalence of mental disorders. And if you add to that mix the complexity of modern families, and again, we are seeing today a profile of families that is much more complicated than it ever was in our history. Many more layer people who've been married once, twice, multiple, blended families. And that is a recipe for potential conflict, as we all know, and it goes without saying. So we put it all together. We're living right now in economic uncertainty. People are under a lot of pressure economically. And you've got this large elderly population that is about to transfer a large amount of wealth. And people, human nature being what it is, will depend on that wealth, on that transfer. And if there's a problem in the family, if there's conflict, if there's mental disorder, if there's undue influence, we could very well see an increase in legal activities related to wills and on this basis. So I'm really trying to make the case for why this is an important topic. Obviously, it hasn't touched a huge amount of the population who've come out to hear about it today. But I can tell you that lawyers are interested in this. But people out in society probably should be interested as well. So, as I said, I'm not sure if people really didn't know what testamentary capacity was and just stayed away. Have we got any idea who's out there yet?
We have 3 people online.
3 people online. Okay,
Yes.
hi all 3 of you out there. Now let's see if I can get this thing to move. Why is it not moving? Seems to have frozen. I better get my slides in case there's a problem. We need this for the group that's out there, right?
Yeah.
So that's by way of introduction to this topic. Now, let's also be clear about this relationship between the law and medicine. Okay, here we go. Hopefully that'll do it. So let's be clear that the issue of testamentary capacity, capacity to execute a will, to determine who gets your property after you die, is a legal issue. It is decided by the law. It's not decided by a medical person or a psychologist. The medical expert and the psychology expert can help the court in making those decisions, but they are not the ones who decide. The decider, the trier of fact in this case, is always the court. Almost always a judge, although in some jurisdictions it's also a jury. So I've tried to triangulate this relationship between the legal concept and the dependence on a medical assessment. It's true in other areas. We do capacity assessments for financial competency, for power of attorney, capacity for personal care, but they are regulated by legal statutes. The government determines what the statutes are that determine the criteria for capacity. In the case of testamentary capacity, it's actually case law. And here I've sort of tried to illustrate what I mean by this. So ultimately the judicial opinion is formed by input from a number of sources. And if I'm retained as an expert to say, did this person have capacity based on your review of the facts or your assessment of the individual? And so the assessments can be either contemporaneous while the person's alive, and then that decision is dealt with later if the will is challenged, or most often the capacity assessment is retrospective, where a medical expert has never actually seen the patient. So we'll talk about, for this case, the testator or testatrix. The term for the person making the will is a testator in the case of a man, and a testatrix in the case of a woman. So here the judicial opinion depends. If I'm expert A, it's only one opinion that the court is considering. There may be a different expert that the other side may have retained, who may have a different opinion or a slightly different opinion. And so it's not just my determination. I am offering to the court my opinion. And there are now clear and very strict regulations about medical experts' opinions. Medical experts now have to sign a form that swears that your first duty is always to the court and not to the person who has retained you. You cannot be an advocate in the eyes of the court. You have to render an opinion that is objective, not prejudiced. And that hasn't always been the case, of course, with medical experts who are hired, you know, the term hired gun in the courts. There are many medical people who are hired guns and are ready to give the opinion that the person retaining them wants to hear for financial benefit, and the courts are no longer tolerant of that, and nor should they be. And I'm, as a medical expert, I'm very happy to be in that position. But so you have multiple expert opinions. The court also takes into account the evidence from other witnesses, and case law is pretty clear that the court values, perhaps more even than a medical expert, values the opinion of people who actually knew the testator or the testatrix during their lifetime. Now, I think that's only partially true. My experience, of course, is that a layperson who knows someone is not necessarily in the best position to determine whether they're capable. There are all sorts of issues. We'll talk about that because knowing somebody on a social level is not the same as knowing what their true cognitive capacity is. And I'll say more about the preservation of social graces and the problem that occurs. That's true of all capacities, but particularly in this case. And then, of course, the court has to go by the legal precedents. What's other case law say about testamentary capacity? And the medical expert is not an expert in the law. My opinion is a clinical opinion. And it's up to the court to determine what the law says, what the criteria are, and to render a decision. So on that basis, so you can see that there are a lot of inputs to the judicial opinion, of which the medical expert capacity assessment is only one. So just to put that in perspective. So the medical expert, not only with the new statutes, has to be objective, has to know that they're acting to the court, not to the person retaining them. And it's a sort of, it's the old story, cobbler, ply thy trade. Doctors are not legal experts. This is a legal decision, and it's the court that will decide. However, in many cases, the court really would benefit from an independent, objective medical opinion. The judges are not expert about Alzheimer's disease and its effect. They are not experts about bipolar disorder and its effect. They're not experts on cognitive assessment. And they need the input of experts in the same way they do in other areas of medicine, right? So if there's a medical negligence case, malpractice case, they need input from medical experts, but the court will decide. So that's basically the background to this. So in terms of the law, well, you don't need to know the details, but in this case, in the case of testamentary capacity, there's actually, this is interesting, there's a single case in law that dominates the discussion around wills. And that's a case that was rendered in England in 1870 by Justice Coburn. And it's known as Banks v. Goodfellow. That's the case. And everybody who knows anything about testamentary capacity will refer to Banks v. Goodfellow. Can people see those? They can see it on the screen because of the sun. And I'll tell you more about Banks v. Goodfellow in a minute. There is obviously, since 1870, there's been a lot of case law related to this. But interestingly, the one case that still dominates and is imprinted in people's minds is in fact the Banks v. Goodfellow case. There is also a doctrine of undue influence that has emerged in case law, and I'll say a little bit more about that later in my talk. So, first of all, when we're talking about capacity in general, whether it be capacity to consent to treatment, capacity to give instructions for a power of attorney, capacity to manage your property, we in society assume that people are capable unless there's other reasons to believe, unless there are reasons to believe otherwise. So there is a presumption of competence. So when somebody goes to a lawyer or somebody makes out a will, they are presumed to be competent. But if there are suspicious circumstances, and I'll tell you a little bit more about what that means, it can override the presumption of competence. So the court will determine when a case should be tried, and it will be often, actually in all cases, it will be because the presumption of competence is overridden and there's now a dispute about whether this individual is capable. And here's where I say beware of social graces. So sometimes there are people who are quite impaired, who have Alzheimer's disease, who have dementia, and yet their social graces are preserved. And if you meet them and you talk to them at a superficial level, you would never detect that they were impaired. And there are many examples that we see clinically where somebody comes in and they're dressed well, you know. I see these elegant-looking ladies, the blue rinse crowd, elegant clothes and makeup, and they preserve their social graces. And yes, dear, how are things? Nice day today. And if you have superficial chit-chat, you may never notice any. But if you start to probe and you say, do you actually know what day it is today? Do you know who the Prime Minister is? Then suddenly the cognitive impairment unravels. And unless you do that, you could be fooled. So this is one of the caveats in determining capacity. Hopefully we'll have time to have some discussion. And actually we have a small group here. I guess the internet people can't communicate. Can they communicate with us?
Yep.
So if there's a question, they can...
Absolutely.
So, you know, I'm happy with having a... If there's something I say that's not clear or you want to question, we got a small group here. Feel free to ask questions or to challenge something that I say. I don't mind that. I'm used to that in court. If you want to get used to being challenged, boy, show up as an expert witness in court. And then the other side has a go at you. And, so you think you're an expert, Dr. Shulman, eh? So the first thing they do is they fight about whether you're qualified as an expert. That's the first debate. And then they try to, you know, and this is another thing that doctors have trouble with. In medicine, we are interested in the objective truth. I should say, well, lawyers are many lawyers. So we try to find, if somebody comes to us with a problem, we actually try to find out what's wrong with them. We'll ask a colleague for a second opinion. We do investigations. We want to know what's wrong with them. When you go to court, the two sides are not interested necessarily in what the objective truth is about the capacity issue. They're there to make the case for their client. We have an adversarial system. So the doctors, the medical profession, is caught in an adversarial system that we are not used to. So I'm there, and the statute says I have to give an objective opinion. Well, I give an objective opinion. But if it's an opinion that doesn't support the other side's case in the dispute, once I've been interviewed or interrogated by the side that retained me, the other side has a go, and they're there to try to destroy you in any way they can. So, anyway, so be it. So, what are suspicious circumstances? When would the court say, you know what, this case, there's a reasonable case here for us to have a trial and find out if this person really had capacity, or is there no case at all? Well, sort of suspicious circumstances. Is this will a dramatic change from expressed wishes? And very often I see the wills that are challenged are ones where an elderly person, for whatever circumstance, at the last minute, just before they die, changes their will. They cut out one of the children, or they cut out all their children, and they give their money to the very an old guy, he's 85 years old and he's got a young caregiver who's been looking after him. Next thing you know, the will's changed, the children are out, the caregiver's in. Well, that's sort of a suspicious circumstance, especially when the children challenge the will because they would be disadvantaged. A deathbed will. And especially if it's a change, somebody's dying, they're slightly delirious in hospital, next thing you know, a lawyer is called, comes to the hospital, the will is changed. Unnatural provisions. Now, here's a tough one. When we say unnatural, meaning, they cut out their family and gave the money to their pet. That happened in the case of, Helmsley, in that famous case. She had this little pooch that she gave $100 million to.
12 million.
How much was it?
12 million.
12 million, all right, so you know better than me. So is that an unnatural provision? And let me just say, so it might be opportune to say this about wills. Wills, the law says that you can be unreasonable in the way you distribute your estate. There is nothing that says you should be fair when you distribute your estate. There's nothing that says you must leave your estate to your children unless they're dependent children. You can do what you want. That's why it's called a will. It's a very fundamental human right. And so it doesn't have to be reasonable. You want to cut out your children and leave it to a religious organization, that's fine. That's your decision, as long as you are capable. And we'll talk about the definition of that in a minute. And the other time that you have suspicious circumstances, if it's clear that at the time the person executed a will that they were suffering from a clear mental or cognitive disorder. Somebody can make that case. This person had advanced Alzheimer's disease when they made that will, and the family or somebody is concerned. That's a suspicious circumstances. Or they had a mental disorder, they were suffering from depression, mania, or where there's complexity in the testator's life. So an elderly person, the family are split, they're fighting with each other, each is trying to influence the testator. That's a tough situation to be in if you're a frail elderly person who's cognitively compromised and your children are fighting around you. Do you know whose argument is reasonable, whose is not? There's a lot of pressure being brought to bear. These are the kind of examples. So let's just talk about, first of all, capacity assessment in general. Testamentary capacity is one of many mental capacities, but we approach them with the same general principles. We look for two things, basically, in a capacity. And if it depends what the capacity is. Capacities are task-specific, as I've said here. Each capacity is different. There's no such thing as global capacity. You might be capable of executing a will, but not capable of managing your finances. You might be capable of executing a will and not giving consent to complicated treatment, for example. So each capacity has to be assessed specifically. That's what task-specific means. And in each task, we say, do they understand the relevant facts? So in the case of a will, do they know what a will is? Do they know the criteria that are relevant to will making? In case of a treatment, do they understand what the treatment is? Do they know what the alternatives are? And do they appreciate the consequences of taking a specific action or not taking action? That's the general principle. Do you understand relevant facts? And do you appreciate what you're doing, the consequences of making a decision? Not only are capacities task-specific, but they're also situation-specific. So in the case of a will, what I'm saying here is that somebody is elderly, they're frail, they sort of know what a will is, they have the criteria, they know they're making a will, and they're in a fairly uncomplicated situation. They've got two loving children, loving wife, and it's not a problem for them. They know they want to give their estate to their spouse, and if the spouse dies first, they want the children to share in the estate equally because they've had a warm relationship all their lives. That's not complicated. And it doesn't take a lot of cognitive awareness to be able to say, this is what I want, and for that to be respected. Same person, now third marriage, 3 families fighting with each other, each making demands on that individual. That's a different situation. And they may or may not have capacity to understand the complexity of that situation. So that's what I mean by task-specific and situation-specific. In general, they have to be able to manipulate information rationally. That is, they need to be able to tell the assessor, or for the court to determine, that they understand the information that's relevant, and then they can make a rational decision. It doesn't have to be a reasonable decision, but look, I'm not giving my estate to my older son because I don't like him. I don't like the people that he hangs around with. That may or may not be reasonable, but at least there's some sort of rational explanation for why you're doing what you're doing. And then finally, in order to be capable, you have to be able to give a reasonably clear and consistent message. So if one day you're saying, I want to treat my children equally, the next day you're saying, no, I want to cut out my daughter, then the next day you're saying, no, I want to cut out my son, and you're vacillating back and forth, at least in my mind, from a clinical perspective, that might be a sign of incapacity. Why can't they hold on to a wish in a consistent fashion? So that would be a concern clinically. I don't know if the law would understand. So what does understanding mean? Well, understanding means a relevant factual knowledge base, and sometimes you have to, if the person's alive when you're assessing them, for example, you have to make sure they're informed. For a woman, for example, let's say a wife, a spouse, whose husband, as not often the case, less often today than it used to be, but very often a wife would depend on her businessman husband to manage the finances of the family and wouldn't even be involved in it. If that spouse dies suddenly and they suddenly take over and they have to make a will, they really don't even know what their estate consists of. You know, where are the bonds, how much is the property worth, if they haven't been dealing with it. That doesn't mean they're not capable, but it means that the person doing the assessment has to ensure that the person at least has been informed and can absorb the knowledge. And that would make them capable. So that's a little, you can see the many twists to the issue of capacity. And then understanding of options. You need to, in a general sense, every capacity, consent to treatment. You need to know, what are my options? My options are to have the operation, to have medical treatment instead of a surgical repair. My understanding is to have a major repair, to have a minor. You just need to be able to understand the options to be considered capable. The appreciation part is really a realistic appraisal of outcome. That is, you need to have some reasonable understanding of what the outcome of making a decision is. So if I decide, for example, am I capable of remaining in my own home? And I'm impaired, I've got dementia, I need to be able to be considered capable of staying in my own home. I have to at least be able to say, you know what? If I stay in my own home, I know that there's a risk that I could fall and break my hip and die because there's nobody around. But I'm willing to take that risk because staying in my own home is more important to me than anything else, and I'd rather take that chance than go into a nursing home. Somebody can express that clearly, then they may be capable despite the fact that they're impaired. You see how complicated it is. That same person who's impaired, who's clearly at risk, says, you know what? There's nothing wrong with me. I am perfectly capable of managing. I do my own shopping when there's evidence that they don't. I prepare my own meals when there's evidence that they can't. Then that person is not capable because they don't have a realistic appraisal of the outcome of taking a particular decision. And they also need to be able to justify the choice. And this is where the rational manipulation of information comes in. And really the key thing is that they shouldn't be delusional. So they shouldn't believe that their daughter-in-law, it's always the daughter-in-law, is trying to steal their underwear or take their money, right? If they believe that and they change their will on that basis, that's a delusion, and the law says that that's a no. So I've tried to illustrate that this is back to the complexity issue. And I've tried to illustrate in graphic form here this relationship between complexity of the environment and cognition. I don't know if you'll follow this, but you see that the law is basically, I've got green and red here, but it's black and white, right? The law, it's not like the world of medicine or the real world where things are gray, you know. It's like, I guess you're either pregnant or you're not pregnant. In law, you're either capable or not capable. You cannot be 90% capable or 20% capable. You're either capable or not. That's the way the law works. And in a will challenge, that's the way it is. The court can't say, you know, this guy was 90% capable, but 10% he was a little off. We'll only grant 90% of his wishes. It doesn't work that way. So here's my relationship. On the y-axis here, the level of cognition or emotional stability, and I've combined it because it's not just cognition. But if you're perfectly intact, high, you're 100%, let's say everybody in this room, let's assume, is got 100% capacity, capable. When you're up there, no matter how complicated your world is or conflictual your world is, you probably will be capable. So no matter how much fighting is going on and demands, competing claims, you're capable. But as you go down the cognitive or emotional ladder, if you're mildly impaired, you have mild Alzheimer's disease, you may be capable up to a point when the complexity moves you from the green into the red. So if things get too complicated, too conflictual, you just can't figure it out, you may not be capable. Did you follow that sort of relationship? And the law has not officially, this is my theory. So, and I'm not a lawyer and I'm not a judge for sure. So this isn't the law. But clinically, I'd like to be able to say to a judge, Your Honor, this is something that you should take into consideration when you're considering capacity. This is the clinical reality that you have to factor in. Any questions on this? Yes?
Even a person that's supposed to be normal changes their capabilities and capacity when they're under high emotional stress.
Right.
So does that mean that person's level, a 98-year-old man who is considered capable, who's under high emotional stress, would not necessarily be incapable and go down the spectrum? Because normal people also go down the spectrum.
Right.
So how do you determine that? I mean,
well, it's a judgment call, but if you were talking about a 98-year-old who was up here,
yes.
All I'm saying is that the court would have to determine that the level of stress would have to be very severe and very, very conflictual before you would even contemplate them being incapable. But it's possible. A 98-year-old who's under a lot of stress is not the same as a 48-year-old under a lot of stress. So I think we have to factor that in. But you're right. I mean, a 98-year-old, just because they're under a lot of stress, if they're intact, they don't have a mental disorder, and they have cognitive intact, then they would be considered capable, yes.
And they also don't speak English that well. So when they're asked questions, you know, only when they wink yes and wink no can you get the true answer.
Well, that's another layer here. I mean,
right.
you
that's
have
what
to
I'm
be.
saying. There are layers.
Yeah, yeah. No, this is a complicated business.
Yeah.
Yes.
So, if I understand what you're saying, so I understand the point you made. It's a good point, but we're talking about cognitive impairment, right? So we're talking about cognitive capability?
Largely we're talking about cognitive, although you could talk about emotional stability. Somebody with a major mental disorder could be vulnerable to incapacity as well.
But so that would be a mental illness, though.
Yes.
So if there was a mood disorder or
Correct.
mania or something. But so, I mean, stress will impact on it, but it won't alter your cognitive capability.
Not generally, although a severe mental disorder can affect cognition too.
But what I wanted to bring out was that the facilitators will look at it and everyone has a different opinion and causes a lot of havoc. And also courts, they look at it, it's black and white, there's no such thing as gray, and all of a sudden you're in a position where, well, courts say he's incapable, the psychiatrists say he's incapable, this, but the people that are actually with that person knows that he's not incapable. So you get into all kinds of conflict.
Yeah, but you got to be careful here. The people who are with that person, I mean, we're talking about a judicial case where there's been a legal challenge.
Right.
So the people who are with that person may have their own opinion, but as I said, unless they are able to do a proper assessment, they may be fooled. It doesn't necessarily follow, although the court does put a lot of weight on the people who knew that individual personally. They will factor that in. But as I showed at the beginning, that also is only one aspect. They need to hear what the experts say. They need to know what the law says. So you can see that this is a complicated business. All right, let's move on. So the law also, interestingly, talks about a hierarchy of capacities. Now, this is something that has troubled me as a clinician. There's a general sense that to be capable of managing your finances is a very high-level capacity. So I've tried to illustrate this relationship between complexity and cognition in different capacities. So for finance, if you started to become impaired, it wouldn't take that much for you not to be able to manage finances. So if you develop Alzheimer's disease and you've got a multi-million-dollar estate that you've been managing, you might become incapable very quickly. So because it's a high standard to manage finances, depending also on the size of the estate, the complexity of the estate, consent to treatment, power of attorney. Wills are considered generally a low level. I object to this hierarchy because, as I said, I believe that every case has to be judged individually. It's task-specific as well as situation-specific. Some complicated wills and complicated families make it a higher. But you'll notice the lowest capacity of all is the capacity to marry. The law seems to believe that capacity to marry, you really just have to be barely conscious, and you can get married. It's not, and God knows that people have made a lot of proven that this is a low capacity. And so that's a whole other issue. We can talk more about that, but just so you're aware that there's out there a belief about hierarchy. So back to Banks Goodfellow. Banks Goodfellow is the 1870 legal case precedent that was adjudicated by Justice Coburn in 1870. And the case was this. There was a fellow whose name was John Banks. He was somebody who had a mental illness. He had actually lived in an asylum in the United Kingdom for most of his adult life. He had delusions about being molested by strangers, and he really retained those delusions to the point that he couldn't function independently, and he was in a mental hospital. But at the end of his life, or towards the end of it, he made out a will, and he gave his estate to one of the nieces that he was close to, as opposed to one of his nephews, and the nephew challenged the will. The court looked at it, noted, the medical experts were there, the asylum. John Banks was clearly mentally ill. He suffered from delusions. But the interesting thing that the court decided, that Justice Coburn said, is that being mentally ill doesn't in and of itself make you incapable with respect to executing the will. And the fact that he was delusional doesn't make him incapable. Only if the delusion influenced the disposition. That's the key. So he had delusions about being molested, but he didn't have delusions about his niece or his nephew. He knew about his money, he knew very well what his estate was, and the court respected his capacity to make a determination of where his estate would go and respect his will. And that's an important principle that's been established. So it's important that having a mental disorder is not in itself an indication of incapacity. It's a suspicious circumstance, but not. You have to know what a will is. You have to know roughly the extent of your assets. The courts have taken the position that you don't have to know to the penny, but if you've got a $10 million estate and you think it's worth $100,000, that could be a problem. You have to have some idea. You have to know at least that you own this property A and property B. You don't necessarily need to know the exact value of that property. but you know you want to give property A to certain person, property B. So that's the extent of assets, so making of a will, extent of assets. This is a term that's in the literature, natural objects of your bounty. That is, you have to know who has a reasonable claim on your estate. In other words, do you know who your children are? Do you know who your family is? Do you know who your good friends are who've been close to you, who've helped you out in your life? If you don't know that, if you're impaired to the point that you don't actually know who your family is, then you may not be capable. And finally, the point about the delusions is you have to be free of a delusion that influences the will. Those are the criteria that emerged from the 1870 Banks Goodfellow case. But 1870 was a long time ago. We didn't understand brain function and cognitive function the way we do today. And there's been a lot of water under the bridge since 1870. Amazingly, the law still, the courts, if you look at judgments, the judges all quote Banks Goodfellow. There's a group of us who've tried to add to that. We've added other things that the court needs to assess. For example, you probably should know if you made a previous will and to what extent this will is different. If you don't remember that you made out a previous will and left everything to your children, and now you're making a new will leaving it to your attractive caregiver, that's a problem for a lot of reasons, but you should be able to at least say, yeah, I know I made a will 10 years ago and left it to my children, but things have changed. I don't want them to inherit it. That's reasonable, but if you don't remember, so that's something that should be probed. Do they have knowledge of prior wills or what their wishes were? Can they give a rationale for the changes? That is, can they manipulate information rationally? That's all you have to do. It doesn't have to be reasonable, but you have to be able to show that you can manipulate the information. Do you understand the emotional, if you're in a conflictual family environment, can you at least say, yeah, I know there's a conflict between my son and my daughter. They're jealous of each other. My son always thought I treated my daughter better. And as long as you can say that, then that's fine. The court needs to know, is there evidence for a psychiatric disorder? So, you know, the family may say there was nothing wrong, or friends may say there's nothing wrong, but maybe there's evidence to the contrary. Have they been clear and consistent? That Banks Goodfellow doesn't comment on that. They don't comment on any of these things, Banks v. Goodfellow. And the old caveat, beware of social grace, preserved social graces. Just because the friends say, oh yeah, I had tea with her the other day, she was perfectly normal. I've seen that all the time. And then when you look at the MiniMental State exam, it's 15 out of 30. It's because the friends don't probe. And somebody who's got the social chit-chat can be deceiving. So these are things I believe, this is where the clinical side says to the court, listen, Your Honor, there's more to the world than 1870 Banks v. Goodfellow when you're adjudicating cases. And I can give you a reference if you're interested. A little bit about undue influence, because very often the challenge is on the basis of lack of capacity and undue influence. Usually because there's been a conflict, or the person who expected or hoped to benefit didn't, and believed that the other side who benefited unduly influenced the person, testator. So what is undue influence? Well, there is a doctrine of undue influence in law, and what it does, there's been an argument that the reason that you can set aside a will on the basis of undue influence, because the law really wants to preserve, in fact, a very low standard for testamentary capacity. In other words, this is a very fundamental right. We don't want to take it away lightly from people. We want people to, even if they're impaired, to be able to determine where their property goes. But if they've been unduly influenced, then we say they were capable, perhaps, but they were unduly influenced. And I'll talk about that. Usually, historically, undue influence, the law said, was coercion. That is, somebody was coerced, you better give me all your estate or else. And the or else could be, I'm not going to look after you, I'm going to leave you rotting in your home when you're dependent on me. It could be another, a more serious threat. But the concept actually has evolved from coercion. It doesn't have to be coercion in the overt sense, but subversion of will, where there's evidence that somebody actually took over the will of the testator. That is undue influence. It's a bit of a subtle. So what are the indications? So the law has listed, when does the law say, yes, undue influence took place? Where the beneficiary has had an opportunity to control the person, where there's been a confidential relationship between the beneficiary and the testator, where the person who benefits actually took the person to the lawyer, said, Mr. Jones here wants to change his will. And Mr. Jones is sort of sitting very passively. Is that what you want to do? Yes. Who do you want to give your estate to? He wants to give it to me. Do you want to give it to her? Yes. So that's the sort of thing. And where there's undue profit, where there's perhaps, and again, this is sort of unnatural provision, where again, I don't want to pick on the young caregivers, but we're seeing more and more of that now, where young caregivers become the beneficiaries and get undue profit from spending a year looking after somebody. Or we have a problem now with young caregivers marrying. It's usually marrying old guys, and occasionally it's the other way around. But usually it's the old men are more vulnerable. So that's a new phenomenon. What are the red flags? Well, they can fall into any number of areas: the relationship, the social, environmental, the legal. I'll just talk briefly about this. The relationship risk. If there's been a position of trust, somebody's in a position to unduly influence, if they're in a position of trust, or where there's dependency. So a daughter comes in, this is a real situation, I see this frequently. One of the children, a daughter usually, comes in, she may or may not be married, often not married, and then devotes herself to looking after the parent in the last few years of their life. That's a major burden. It's a major stressor. They sacrificed a lot. And at some point, they say to themselves, you know what? Look at me. I've devoted my life to my mother to look after her. My siblings are out there living their lives. And they're going to inherit the same as me. That's not fair. And they say, Mother, you better give your estate to me because I'm looking after you. Now, there's nothing wrong with that in and of itself. But if that person is impaired, it becomes problematic. And if you subtly threaten that person by saying, Mother, you better look after me because if you don't, I'm not sticking around. This is too much for me. You want me to care for you? You want to be looked after? You want to feel safe? You better leave your estate to me. And then the court has to decide if that's undue influence. So that's the sort of thing that can happen. If a person's been isolated, the influencer will sometimes isolate that person from the rest of the family. And if they're impaired, what I've seen often, they convince the person, they don't allow phone calls, they don't allow visits, they isolate the person. And somebody with Alzheimer's disease says, geez, you know, my son, he hasn't visited me, he doesn't call me, that son of a gun, I'm going to cut him out of the room. And the daughter encourages us, yeah, he doesn't visit you, I look after you. And then there's a will challenge. That's the sort of scenario that can occur. So you just need to be aware that these are some of the factors. And the other red flags, again, I mentioned when the beneficiary actually takes the initiative to get the will, calls the lawyer, arranges for everything, where there's undue benefit, where it's not consistent with other wills. So that's why the prior wills become an important issue. And where there are changes, all of a sudden the power of attorney changes, as well as the will. Those are the indications that maybe there's been undue influence. Now, what about the role of the expert? Well, the expert's role is not to determine whether influence was exerted. Let's be clear. A medical expert does not give an opinion as to whether, that's a matter of fact, and that's a matter for the courts to determine. All the expert can do for the court is give them an indication of the extent of vulnerability that that person may have had on the basis of cognitive impairment, emotional, and to define that level of cognitive impairment or emotional instability for the court. So the medical expert can say, Your Honor, this person suffered from Alzheimer's disease of a moderate to severe degree, and therefore would have been very vulnerable to undue influence if that influence in fact occurred, and that's your decision. And also to identify misperceptions or delusions that might have influenced the decision. And I'll give you examples of that in terms of cases. So again, the issue of influence is also relative. Ultimately, it's a black and white decision, or green-red decision here. And I think it's relative. So again, the more intact you are, it would take a tremendous amount of coercion to be considered undue influence. However, back to your point, no matter how intact, every one of us, I think, in this room, I suspect, let me speak for myself, if somebody kidnapped me, a bunch of kidnappers, they took me away somewhere, they isolate me, they take a loaded gun to my head, and they say, buddy, you're going to change your will. You're going to cut out your family, you're going to give everything to us. Bad guy A and bad guy B. And there's a gun to my head. I'm probably going to change my will. Right? Under those, no matter how intact I may be or not be. Now, I would think that the court would still consider that severe coercion and undue influence and set aside that will. But it would take that level of coercion. However, if I'm quite impaired or severely impaired, it may not take much, even suggesting to a very impaired person that they should change the will. And they don't really know what they're doing. I mean, this is where there's a blur between capacity and undue influence. But as far as I'm concerned, telling an Alzheimer patient of a severe degree that they need to change the will and taking them to the lawyer and getting them to change, even if you're not threatening them, even if you're being sweet, listen, dear, just sign here in the dotted line. Well, you don't have to if you don't want to, it's okay. But even that degree of influence could be considered undue. So it's all relative. And I'm trying again to show the court that this issue, this legal issue, is relative to the situation and to the cognition of the individual. Does that make sense to you guys? Doesn't always make sense to the court. So a little bit about brain functions. I don't want to spend a lot of time. You might be interested in how does a medical expert determine somebody's brain function? How do we assess brain function? Well, the functions that we think are critical for executing the will relate to the two components of capacity, that is understanding relevant facts and appreciation of the consequences of taking or not taking action. And that involves, you need to know roughly where you are, you have to have some idea of your circumstances. You should have intact memory or relatively intact memory because you need to know what your assets are, you need to know who the people in your life are, and if your memory is impaired to the point that you don't know that, you could be lacking capacity. You have to have intact reality testing, that is if you're delusional or having hallucinations that are influencing you, you may not be capable. So an expert needs to be able to assess those aspects of brain function, and perhaps most importantly, what I call executive frontal functions. Executive brain functions are really the higher level brain functions that affect judgment. The frontal lobe is what you need for good judgment. Now, there are people who've never had good frontal lobes, so that's an issue too. But you have to be able to, so how do you assess that? That's the question. And what do the executive brain functions do? Well, they determine how impulsive you are, whether you're apathetic, that's frontal executive brain functions. People with brain damage may sometimes show only that with good memory. To think in an abstract way requires higher level brain functions. To be able to plan ahead, to be able to know what consequences of taking certain action require higher level brain functions. And as I said, judgment. That's a very tough one for the law because people are entitled to have bad judgment. But where there's a change from their norm, that's the concern. So if somebody has behaved in a certain way all their lives, then develops Alzheimer's disease and loses that judgment or has a little stroke that affects their judgment or their impulsivity, that could be a problem. So those are the sort of things that an expert has to assess. Vulnerability. Remember I said that the medical expert is not determining whether influence occurred, but whether they're vulnerable. And these are the sort of things you look for. Somebody who's very anxious And very often, Alzheimer's patients are very anxious. They can't figure out what's going on in their environment. Things are changing. They're overwhelmed. They're vulnerable. If somebody comes along and says, oh, listen, dear, I'll look after things. You don't have to worry. I'm going to buy things, food. I'll buy food. I'll solve the problems for you. That's potentially vulnerable situation. If they have paranoid beliefs, people with dementia very often have paranoid beliefs. As I said, most often it's the daughter-in-law who is the object of the paranoia. But if they believe that one of the children is stealing things from them, that might be very upsetting. So, you know what? That daughter-in-law is stealing things. That's terrible. I'm cutting her out of the will. And it's very common in dementia. Stealing delusions are the most common because it's compensatory. They don't know that their memory is the reason they don't remember where things are. They're trying to find an explanation, and the simplest explanation, and sometimes the most desirable, is to blame the daughter-in-law. So, and they have poor judgment. So these are all factors that may lead to vulnerability. The common conditions in old age, dementia, prevalent in 8% of people over 65, in over 25% of 85-year-olds and over, very prevalent. We know there are different types of dementia, Alzheimer's, Lewy body, vascular dementias, etc. Alcoholism and alcohol abuse is a common condition that affects capacity. So you have to be concerned about that. Mood disorders and paranoid disorders, but paranoid disorders are often secondary to cognitive impairment. So these are just examples of the kind of conditions that could affect capacity and vulnerability to influence. And this is the sort of thing that a medical expert should be helping the court with. Judges don't understand the ins and outs of these conditions. So what do? Well, this is assuming that somebody is alive and you have a chance to assess them, or you look in the medical records for examples of these type of assessments. Do you know about everybody know what the MMSE is? It's interesting, this is so common. No? The MMSE stands for MiniMental State Examination. And it's one of the common cognitive screening tests, or the full steam MiniMental State Exam. Very common one. Even some lawyers are doing these things now. It's scored out of 30, and that's usually a measure of cognitive functioning. The clock drawing test. Anybody know what the clock drawing test? I'll show you some examples. I have a particular interest in that screening test. And then there are tests that actually test frontal executive function. You can actually sort of have a proxy for whether this is affected, and there are other tests that are low. So this is where the medical expert can help the court. The most common ones are the MiniMental State, the clock drawing, and set shifting, which actually tests frontal executive function. So it's a cognitive test that determines whether an individual can shift mental sets. Do you know what I'm talking about here? Anything that requires the brain to alternate mental set. The most common, one of the common ones, for example, is called the Luria test. Luria was a Russian neuropsychologist, and it's actually a very simple test. You get the person to hold out the palm of their hand, and then the test is this. I want you to repeat what I do. Fist, side, palm. Fist, side, palm. Everybody do that? Fist, side, palm. Fist, side, palm. You're struggling. Careful. All right, so you can see, and that is a test of alternating sets. If you can't do that, you're not capable. Now, having said that, these are not diagnostic. So you don't make a diagnosis on the basis, and it's not a measure of capacity, and that's a mistake that a lot of people make. Just because you do poorly on a MiniMental State, but it's a reflection of what your functioning is like, and it has to be factored into the big picture. But there are limitations to the MiniMental State. I don't want to go into a lot of detail, but the MiniMental State, which is the most common one, does not test frontal executive functions at all. Strictly memory. There's a intersecting pentagons, if you're interested, we can talk more about that. But it's a limitation. So just because you score poorly on this test doesn't mean you are not capable of making out a will, or that you're not capable of looking after your property. But it is a measure of your cognitive functions. Clock drawing has become another popular test. I'll just show you some examples just for fun of what these tests can reveal about brain functions. So when you're asked to draw a clock, and the test goes like this, I give people a pre-drawn circle, and I say, this is a clock face. Put in the numbers first, that's the first part, and then I say, set the time to 10 past 11. That's the test. Place the numbers, so I want to see if they can organize the numbers properly. And then I say, set the time. You know, that's very important. The words are important because I don't say, put the hands in, because some people who are impaired don't actually remember that you set time by hands. So I'll show you some examples of what you can learn. But in order to do a clock properly, there's many brain functions involved. It's not just visuospatial. You have to understand what a clock is. You have to think abstractly about time.
In the modern world.
Oh, I know what you're going to say.
Yeah.
Stop right there. Stop right there. The digital clock. I know you're going to ask me.
I was just going to say, there's people who use cell phones. They don't even know.
Yeah. Things may change, but right now, most people know what an analog clock is, or should, right? Certainly most older people. The 20-year-olds of the future, I don't know. But you're right, that's a consideration. So abstract thinking. Set the time to 10 after 11. That involves abstraction because it's a symbolic representation of time, right? You point to an 11 on one hand, and then you point to a number 2 that means 10 minutes after the hour. That's a bit counterintuitive. You have to understand the symbolic use of numbers. You have to be able to plan. When you're doing the numbers, you have to be able to plan ahead so that you don't scrunch them all onto one side. 1, 2, 3, 4, 5, 6, whoops. I hear that all the time because they haven't planned ahead. So it's a test that can determine visual memory. You have to remember what a clock looks like, organization ability. You have to be motivated enough to do the task. And then you have to be able to inhibit the stimulus. When you hear the number 10, I say set it 10 after 11. You can't just point to the number 10. You got to remember, oh no, I'm not pointing to number 10. I'm pointing to number 2, which is 10 minutes after. So it's more complicated, and that's why it's a good screening test. A screening test should try to cast a wide net for cognitive function. So I'll show you some examples, just to highlight this. So these two, there's a classification system that's not important. 5 would be an intact clock, and that's more or less intact. I'm not looking for perfection. Perfection is the enemy of the good, right? That's what they say. So these are two clocks that I would rate as pretty much normal. They organize the numbers well, you know, it's well spaced. There are 2 hands, one pointing to the 11, one pointing to the 2. You could argue, well, the 11 should be the short hand, the 2 the long hand, but that's good enough for most purposes. This person has pretty much good cognitive function. Then you get into milder forms of impairment. See, the numbers are sort of on the edge. So, well, that's not bad, but it's not quite right. Here's your planning problem. They ended up here when they should have ended up here because they didn't plan ahead. So some people have the capacity to anchor. They put a 12, a 6, because they're organized. Not everybody, you have to have a good frontal lobe to do that, right? And here it's got micrographia. Small, you know, they haven't used the circle, the boundary properly, although it's well organized. And then this is an interesting one right here. Somebody looked at that clock and said, this person also has obsessive compulsive disorder. They put in every little. It took them 2 hours to do that clock. But there's an interesting feature. Look at the numbers here. See, they're upside down because they turned the page while they were doing the clock. Anybody who turns the page is demented. So that's those represent mild impairment, and then you can get more severe impairment. And here you can see the problems with 10 after 11. These are all people who've pulled to the 10. And even though their numbers are not bad, their abstract ability is impaired, and they've all gotten So this person actually wrote the number 10 after the 11th. And that's a common mistake I see. Again, an example of concrete thing. So the point of this is that these little screening tests tell you a lot about brain function, and there's ways to assess it. And then you get the more severe impairment. And here this person just perseverated, just kept going repeatedly, and much more severe. And here, of course, it doesn't take much to know that this person is quite impaired. But these are all examples. The clock is also used to show improvement. This is a series of clocks from a person. When I was training, I discovered this by accident. I asked a man who had a stroke. He had a severe stroke, and he was actually in a geriatric hospital in London, England, where I was training at the time. And after the stroke, he had a pretty bad depression. And he was crying a lot, and the doctors put him on an antidepressant, but they put him on a very high dose of a anticholinergic drug. And actually, I saw him 6 months afterwards, and he was severely impaired. And it was probably more on the basis of the medication, I thought, than the stroke itself. So at day one, when I saw him, that's what he drew when I asked him to draw a clock, among other things that he got wrong. So I stopped the antidepressant. I went back to see him 2 weeks later, and I asked him, just by accident, to redraw the clock, and I could see that he was doing better. I said, well, maybe we've done something right. He's moving in the right direction. And then 5 weeks later, same person draws a perfectly normal clock. So it picks up the change in his brain function. It's a good test for that reason. And clearly this was a toxic delirium. So again, examples of how cognitive screening tests can be helpful. I don't think you can see this very well, can you? These were people with dementia that we followed over time to show that the clocks got worse as their dementia got worse. So here's somebody this is the person who wrote the 10 after the 11, and a year later could barely draw anything. So it's a sensitive test. And then here's your question about the digital clock. Somebody's always asks me. So a couple of friends of mine wrote into a journal that in the future, the digital generation, this is what the clock's going to look like. Mild impairment, 10 after 4, they're going to perseverate on the circle. Moderate impairment, the numbers start to fragment. And then when they're severely impaired, they draw a perfectly normal analog clock. They regress. It's a joke. It's a joke. Actually, today, for example, if I see a Roman numeral clock today, that person is demented until proven otherwise. It's a throwback. So you can learn a lot from clocks. So the frontal tasks, there are many tasks we use, just so you know. Verbal fluency, generating words. So there are two types. Phonemic prime, we give people the opportunity to give us as many words as you can think of that begin with the letter F. And they have 60 seconds. A high school educated person can usually generate at least 12 to 14 words on that. Sometimes you see disinhibition, and the first F word they give you is surprising. Sometimes that's a sign of disinhibition. Then there's a thing called semantic prime, which is like a four-legged animal. Name all the four-legged animals. It's a slightly different test, but that tests frontal functioning. I mentioned the alternating hand movements. There are other tests that we can use. We can talk about that. The ultimate question, though, is, does the testator have the task-specific capacity to execute a will in the context of their specific environment? That's the ultimate question, based on all the factors that we've talked about. So I think what I'm going to do is just end with a couple of case vignettes, just examples of cases that I've had exposure to that highlight some of this, and then we can take some questions or talk about this, all right? So here is a case of a radical change with early dementia. This was actually a case that I testified at in Alberta. Bar Review Zitterak, it's in the case law. It was an 84-year-old woman, testatrix. She had an only daughter who lived in Ontario. She lived by herself in Alberta. And 3 years before she died, prior to death, she changed her will. And what she did is she cut out her daughter and her daughter's family with whom she'd been close all her life. and she left the entire estate to a newfound nephew whom she'd never seen until just a few years before she died. What happened was she was developing dementia. She was getting very anxious. She's living alone in her home. She couldn't cope. And the daughter would come in, once every few months. She got very suspicious about the daughter. And this nephew arrived for some reason, and he started to shovel her snow in Alberta, which was important. He started to look after things. She became very dependent on him. And as she got more and more dependent, we don't know whether the nephew influenced her, but she changed her will. Cut out this daughter with whom she'd had a very warm, close relationship all her life. And this was a case where she was developing dementia, had perceptual distortions about the daughter, and didn't really appreciate, I didn't think, the impact that this would have on the daughter and her grandchildren. Did she really think through what this was going to mean to her grandchildren if she cut them out of her will? And the court ruled that this will was invalid. There was suicide was an interesting one. An 84-year-old single man with no children, a month before he died, made a radical change. He cut out his niece, with whom also he had a very warm relationship. She was looking after him, but he was now getting more and more anxious. He was very worried about his health. He was desperate for security. She couldn't come over often enough. Similar story to the first one. The nephew arrived, and within a short time, he switched over his estate to the nephew, cut out the niece with whom he had a lifelong relationship, and then he killed himself. He was probably developing a severe depression, suicidal ideation, desperately trying to deal with his anxiety, and that's another example. Then there's the man who made multiple wills. He was a 99-year-old testator. He was in a common law marriage for 60 years but had no children. This is very common. Where there's no children, it's even more problematic. And what he used to do is, as he got older, the way he dealt with his insecurity is he would promise his estate to various nieces and nephews if they would look after him properly. So he just kept changing. That was his way of actually... So the question is, he was controlling and manipulating his family, but he made at least 7 or 8 changes in his will, at which point, was he competent? Was it just the last will by chance that should stand, or was he not capable because of the changes? And that was an interesting question in that case. Here's one where there was a radical change, but the person was capable. An 89-year-old woman, she had left her estate equally to her 2 sons. And the son who was poor, one was wealthy, the other was poor. The poor son became her primary caregiver. Remember, I was giving you an example of that. And he took over. The wealthy son was not involved. And she went to a lawyer and changed her will to give everything to the poor son. But she was able to manipulate information rationally. She was able to say, I have 2 sons. One is wealthy, one is poor. This one needs the money. He's looked after me. The other one is wealthy, hasn't been as involved, and I want to leave my money to the poor son. She was deemed capable, but it's not a good idea to do that. Let me just tell you. It is not a good idea in general to even the playing field through a will, because no matter how wealthy that son was, and no matter how much he knew that it was the younger son, when the will says, I'm giving it to one son and not to the other, that is hurtful emotionally. That is hurtful. And if it's hurtful, it can lead to challenges. But generally, I think lawyers who do estate planning will advise people that if you really want to even the playing field, do it while you're alive. Give this poor son whatever money he needs to live, but when you leave your will, treat them equally. Even if you've given away 90% of the son already, as long as you're doing it in a capable fashion, emotionally, it's a lot more palatable to have a will that treated the 2 sons equally. So that's a bit of a estate planning lesson. It's nothing to do with capacity assessment as such. All right, let's stop there, and I'm happy to take some questions.
It's interesting. 10 years ago, I had a 98-year-old father. My mother died, my brother died, and I was the only one left. I knew nothing about everything that you're talking about, because the information, at that time, I just wasn't interested. I was in New York and came back. I'm learning and gobbling up information today that is freaking me out, because at that time, nobody knew. The courts were not aware of this man. Nobody was aware of anything that was going on, and everybody was arguing and fighting. And what I had to do was I had to hire a person through the public guardian and trustee, bring that person into the house to spend a week with this man and tell me exactly what they thought. Not medical, not the courts, not any, I just needed to know, morning to night, 7 days a week, what was going on. And she said that he was okay, that he knew exactly what was going on, he had doubts about certain things, and only at that point was I able to go back to the courts and back, whatever, with this testimony. And what really upsets me is, well, they're gone 10 years now, and I'm just learning all about it, and I mean, I'm 70 now, and I'm scared to death about where I go with all of this, because I saw repercussions that happened that were mind-blowing.
Yeah, well, you raise, I mean, I can't really comment on individual cases,
No, right.
but I mean, you raise very appropriate concerns. That's why I say there are going to be more legal challenges, because we're living in a complicated society now. Lots of mental illness in older people, lots of money being transferred, lots of conflict in the families. That's ripe for problems. Not just in wills, but in caring for the person, determining where they live, how they live. And that's why geriatric services have to be very aware of capacity issues. They have to know how to deal with public guardian trustee. They have to know what Substitute Decisions Act is. They have to know what the statutory laws are, what services are available. And I assume that that's a big part of your course on life, aging and life.
You also have to know what lawyer to deal with, because the medical profession has certain ethics they go by. But a lot of the lawyers do not have the ethics to be able to deal in a way that they consider, like you said, you consider the court instead of your client, because the court was very important. Well, the lawyers consider themselves instead of the court, and instead
Well,
of
it's
the
not
client.
appropriate for a doctor to make comments about the legal, and I get into big trouble with that.
It's just
But
like
your
a
point is well taken.
Okay.
Your point is well. Any other comments? Yes.
No, I'm wondering about the whole area, like just thinking about wills, and I'm moving my mind onto the whole area of elder abuse and the whole area of financial abuse of older people. And I'm wondering, I'm thinking a lot of this has to be applicable to that particular situation.
Yes.
And I know, for example, that I actually gave a talk to a bunch of Supreme Court's judges for Canada. And I was absolutely dumbfounded at their lack of information or even aware of the issue. And wills, obviously, they're going to know, but to some degree, but I'm quite concerned, like we're going to go, like, there'll be more of this, just like you're saying, in terms of the will issues and so on. And some of the financial stuff you're talking about in the will is related to financial abuse.
No, that's true. I mean, it's a form of financial abuse, actually. Influencing somebody to change their will is a form of financial abuse.
Yeah.
But the only recourse after they've died is through the courts.
Yeah, I know. And the courts need educating.
Yeah, your point is very well taken, and we're seeing more and more of this. You know, my colleague Carol Cohen, some of you know, who's very involved in this area, does home visits on elderly people, and it's not infrequent while she's there that there's a phone call from the local real estate agent who wants to sell the house, you know, or buy the house, even better, for half the market value. So there's lots of vulnerability out there. And that's where we have to have safeguards. That's where substitute decision makers have to step in and have an obligation. That's where the public guardian and trustee may have a role. And sometimes the courts themselves in awarding guardianship. So these are, again, all of these are increasing issues. The will is just one element of what is a larger problem that you've rightly highlighted.
You know, the biggest problem that I found is that the man, the elderly person itself is in such an abusive situation because this one's fighting, that one's fighting, the courts, the doctors, this, and this poor person is sitting there not knowing. When he died, I just said, I'm sorry, I didn't know how to help you better, but everybody had an opinion, and this man was abused to the end.
Well,
Which is very sad.
Yeah, it's a very difficult situation.
Uh-huh.
And that's where physicians, social workers, others who work in the community need to be aware of these issues. Any other questions?
I just wondered how many experts now in the medical field are available that are aware of all of the facts.
Related to capacity in general?
Yes, and being able to.
Well, there are, first of all, you have to be aware there is a group of people called capacity assessors,
Right.
trained by the Ministry of the Attorney General. There's a capacity assessment office, and if people want a capacity assessment, they are available. By and large, they are not physicians. There are just a very few physicians. They are often psychologists, nurses, social workers who've been trained to do capacity assessments. And so that is available to people if it's necessary. And by and large, I think they do very good assessments. Actually. And sometimes they do better assessments than the average GP who really doesn't know the issues. So you're better off getting the capacity assessment. I tend to restrict myself to the wills issue.
Right.
It's a very specific area, and only when the courts are involved. So I don't do the regular capacity assessment. And there aren't a lot of physicians who do that.
You said something about.
Let's just see if is there anybody online who has any questions?
No questions on that.
No questions? Anybody else before, because we only got a couple minutes left. Anybody else? Otherwise, go ahead.
Sorry.
Well, you've got a lot of questions, but I want to give everybody a chance.
Right. You said something about after 65, that is a phrase, I didn't really get the whole thing, but you said something that from after 65 you have problems.
The prevalence of dementia.
Okay.
The epidemiology is, well, I'm glad you raised that, because we normally, in epidemiological terms, in population terms, we consider the elderly to be 65 and over. Now, as I get closer myself to that age, I think it's ridiculous to consider that as the cutoff for the elderly. 65 it used to be old, but it's not today.
Thank you.
No, not at all.
No. Let's say I have validation for it.
Not at all.
The truth is that, in my opinion, 75 isn't even old. The average, I would think middle age today goes at least to 75. 75 is late middle age. The average 75-year-old, certainly a 65-year-old, but the average 75-year-old in our society is a cognitively intact, fully independent, healthy individual. They may not be able to play singles tennis the way they once did, or run a marathon the way they once did, but they are independent. They're not people who are dependent on anybody for anything. Why consider them to be elderly in a sense of being frail in any way, dependent? So from a societal point of view, and the numbers reflect that. What I was talking about was the prevalence of dementia, cognitive impairment. If you look at 65 and over, all 65 and over, which now represents like 14% of the population, the percentage is about 8% of everybody over 65. But when you look at over 80-year-olds, then the prevalence jumps to over 20 or 25%. So that tells you the difference. If you just looked at 65-year-olds, about 1% of them suffer from dementia. So you're right, age is a factor, and 65 should definitely not be considered old. The problem is it was tied to the idea of when you get a pension. And so you get a pension, you're old. Your status changes. But functionally, it's not an appropriate age from a societal point. Any final questions, comments?
I just have a question, but it is about capacity assessment when somebody is alive, obviously. But so
Well, I do make capacity assessments on dead people too.
Well, yes.
They're retrospective assessments. People, at first, when I first started doing this, the lawyers would call and my secretary would say, Dr. Shulman restricts himself to the practice of dead people only. But now I will see some people who are actually alive. So go ahead.
So, just take for a general example, if we hired a capacity assessor, is it always adequate to have a single assessment?
Well, you raise an interesting point. Sometimes you should do more than one assessment. Sometimes it's not entirely clear. And as I say, in the real world, things aren't black and white. And it may be that you're not quite sure. This person is sort of on the borderline. I'm not sure. In that case, it is sometimes worthwhile doing a second assessment a few weeks later to satisfy yourself that the person is consistent and that what you found at the initial assessment. So that's a very good point. And there's sometimes a case for doing more than one assessment. Okay.
Shulman, I thought that was very important because I know that with my father, he would act one way with one person and have completely different answers with other people, which is something that I found out was the basis of the problems that I was having, which I didn't understand.
So you're highlighting again the complexity and the difficulty, the challenge of this task of doing capacity assessment. So sometimes you have to get multiple sources of information. Sometimes you have to do it on more than one occasion. You need to do a comprehensive review. These are challenging issues, but I think the reason I wanted to talk about it today is that it's increasingly common and important in our current aging society. So with that, thank you very much.
Wonderful, thank you.